Good afternoon. I suspect everyone's here. Mr. Mendel, I see you. Dr. McDonald, I see you. The rest, I see Mr. Stern. Good afternoon, Mr. Stern. I suspect that the rest of you are either witnesses or hanging around with one party or the other. Okay. All right. Mr. McDonald, you're the plaintiff. Uh, Let me ask you a question, and so I'll make sure we're all on the same page. You filed a motion for leave to amend the writ of mandamus. Am I correct?
I'm sorry, sir. I didn't hear you. Can you say that one more
I
time?
said you filed a motion for leave to amend the writ of mandamus,
Yes, sir.
and you included that in your court map uh, uh, area with your witness list. Are you moving to amend your writ of mandamus?
If we could make the writ of mandamus the operative complaint, I think that would serve justice and be easier for everybody. Um, Before I served the amended writ, I had first filed the First Amendment petition when the city had given me more records, so the facts had changed. I filed a bunch of notices of filing throughout the case due to more facts changing, more facts coming in. The amended writ just takes into account that and makes it clear that I'm requesting not just mandamus relief, but declaratory injunctive relief as well.
So you still wish me to hear the motion for leave to amend? Is that correct?
If we could get that entered, I think that's the best way to go.
Well, I have to. Either I'm going to entertain it or not. If you want me to entertain it, I will. You're going to have to tell me why you wish to amend at this point, and if there's any objection on the other side, which I'm sure there will be. But we'll wait and see.
Okay. It's just to clean up everything and get all the facts into one pleading with an affidavit, and to make my pleadings for relief clear. That's why I would like it entered. If it doesn't get entered, I can still argue based off of the First Amendment.
All right, Mr. Mandel.
Yes, Your Honor. Good afternoon. Yes, we would object to him seeking leave at this point. I mean, one of his counts, count one, is still his mandamus, but proposed count two is an action for declaratory relief. Count three is an action for declaratory relief, and count four, it's injunctive relief, and count five, it's injunctive relief, and really, it's superfluous. It's unrelated to really the underlying petition. Petition really is, did the documents get produced or not? And if they weren't, then he seeks mandamus relief. This is going way above and beyond and way
Well,
afar.
that may be true, but the question being is how you prejudiced by the amendment.
Well, we're not. If he wants to seek leave to amend, Your Honor, he has the right to do that. I wouldn't disagree with that. But for purposes of today's hearing, he can't, amend it and then argue it simultaneously. The only thing that's salient for a 11911 hearing, which is why we're here, we're not here for a final hearing on the merits.
I know why we're here. I
Right.
got it.
So he can't have his cake and eat it too. He can't amend and then argue this whole amended petition. So it's really his choice how he wants to proceed.
Mr. McDowell, I figure that's what he would argue because this is the standard argument. I don't have a problem giving you leave to amend. Honestly, you have a right to seek leave to amend even at this stage of the proceedings. So I would give you leave to amend. The problem with giving you leave to amend, which I'm going to leave it up to you, is that we would have to postpone this hearing, give the defendant an opportunity to respond. That the hearing wouldn't be at issue based on your amended petition. Therefore, we would have to reset the hearing and let Mr. Mandel and the city be able to obtain documents and prepare for a defense on the rest of your counts.
I understand, Your Honor. In that case, I was hoping that we could get this case out of your hair and dispose with today, if possible.
Hey, I got no hair. So
if we need to come back to finish up for the declaratory relief and the injunctive relief request, and which is what we need to get the amended complaint entered to happen, we can do that later. But everybody's here today for what we need for the mandamus.
I don't have a problem. Well, if you want to go forward today, then I would have to deny your motion to amend without prejudice.
That's absolutely fine, Your Honor.
Okay.
And then I could
So everybody,
refile after today's hearing, depending on how it goes.
well, you would have to do other things. So
Okay.
you're, without prejudice. I'm not foreclosing you to do anything.
Okay.
Okay. All
I
right.
just want to make
Well.
sure that I preserve my right to seek the declaratory injunctive relief.
Okay. So right now it's denied without prejudice.
All right. Thank
Okay.
you, Your Honor.
Well, you may proceed. Can I have an opening statement? Just a short, brief history of the case, and Mr. Mandel and the standard of review on my part.
You would like for me to proceed, Your Honor?
Not right now. I want Mr. I want the doctor to go ahead.
Okay.
And
Yes, sir, Your Honor. On February the 18th, 2019, I filed the request that's at issue. In the request, I was asking for all records related to any leave ad infinitum taken by Officer Merguido throughout a certain time frame. I was looking to see if Merguido was out of state, and that was to see if I could toll the statute of limitations in another case. This is why I filed the request. The records show, and Paula Carbolosa and Elizabeth Sewell, who are here, their affidavits show that the request was filed on February the 18th. On February the 19th, the clerk's office forwarded the request to Ms. Carbolosa. On February the 20th, Ms. Carbolosa retrieved the records, the first set of records, and then waited 19 days after retrieving the records before producing them, which was after I filed the lawsuit. And that's what led to the first amendment, was when they had given me the set of records after I had filed. The issue is, when I reviewed the records they had given me, they had not produced all responsive documents. To date, they've given me 5 sets of records at 5 different times. In my response to my repeated complaints and arguments, they had not produced all responsive documents. There's still a 6th set of responsive documents I believe is still outstanding, and I have evidence to show that, and we could rely upon testimony to ferret that out as well.
okay, Mr.
And
Mandel.
so for the
Oh, there's
mandamus,
more. I'm sorry.
for the
I'm sorry. I
mandamus,
thought
I
you
would
were.
request just that the city be forced to give me the records, and that the city, if they are unlawfully found to withhold the records, that I would be entitled to my cost.
Okay. Thank you, Mr. Mandel.
Good afternoon, Your Honor. This is a petition for a writ of mandamus about a single public records request for documents relating to any leave by Officer Merguido from the city's police department between April 9, 2013 and April 9, 2015. All responsive documents from the city were produced 2 years ago. The court properly held in dismissing the petition on April 17, 2019, that all documents regarding Officer Merguido's leave were indisputably produced. Plaintiff has appealed it on the technicality that a hearing wasn't afforded under 11911. We agreed. We sought relinquishment of jurisdiction. He wouldn't agree absent a condition that he take depositions beforehand, which we said that he's not entitled to. So now we're back here for this 11911 hearing. The only issues that can be decided here today, to answer your question that you posed earlier before, is whether all responsive documents have been produced or whether there was any improper exemptions. Well, there's no assertion that any of the documents that were withheld were improperly withheld based upon, the fact that they were medical records or Social Security numbers. He doesn't assert that any documents that were withheld were improperly withheld. So there's no need for an in-camera inspection. Also, whether there was a delay in the production of documents, that's also not an issue. The documents have been produced. The delay issue is part of his declaratory relief and injunctive relief. Similarly, the issue about whether or not he was charged too much for the production, he can't raise that here today. Why? Because the city produced everything and didn't charge him a penny. So really the only issue here today to be decided, Your Honor, is whether any additional documents were not produced. There is absolutely no evidence other than Mr. McDonough's rank speculation that additional documents exist. There's nothing that will change this court's eminently correct result previously found 2 years ago in dismissing the plaintiff's action. And I could go through what the evidence will show, but it's really Mr. McDonough's case.
All right, Mr. McDonough.
All right, Your Honor. First,
yes,
I
sir.
want to make an objection to Mr. Mandel's claim that all records have been produced to me. There is no evidence on the record whatsoever that all records have been produced to me, other than Mr. Mandel's repeated claims and the unsworn statements of counsel do not constitute evidence, which is
I,
clearly
I, I don't
established.
I don't I don't disagree with you. He's not testifying.
It,
He's just putting forth an argument. Doesn't
it,
mean you got to prove that documents were
well,
not produced.
I understand, Your Honor. May I share my screen?
Sure.
Just
Well,
real
well,
quick,
well, hold on. Before you do that, you either have to testify, Mr. McDonough, or you put on some evidence as far as other witnesses. Uh, so, who do you want to call as your first witness? Let me ask you that.
Well, first off, I would like to show documents.
You can't show documents unless they're in evidence.
I have submitted them as evidence, Your Honor. They're Exhibits R and Exhibit S.
But that's not the way it works, Mr. McDonough.
Okay.
Unfortunately, I wish you were represented by counsel. So we would, but the way it works is that you have to produce the evidence you have to move the evidence the documents into evidence by a witness laying the predicate or by a records custodian. I can't tell you I can't teach you the evidence code as we sit here. Unfortunately, I like to because that's what I also teach, but I can't. I'm not allowed to teach you as to how to do it. So all I can tell you is
Can I go under oath and swear to documents that were provided to me by the City of Homestead?
you can go under oath, and then if there are objections, then we'll hear the objections, and then we'll see, and I'll rule on the objections. I can, but I can't tell you what and how to do it.
I understand. Well, I'd like to go under oath, Your Honor, and I'll
Okay,
testify, and I'll show documents that support my testimony.
that's fine. Uh, um, Raise your right hand. I know who you are, Mr. McDowell. So,
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
okay,
Hand down.
you put your hand down. All right. State your name for the record, Mr. McDonald, so the record will know who's testifying.
Dr. James Eric McDonough. I'm the pro se plaintiff.
Okay. All right. Tell me what you want to test. Tell me your testimony.
So I explained that I was looking for Officer Merguido being out of town. In the first set of records provided to me by the city, which they have entered as part of their exhibits, it shows.
Well, let me put it. Let me tell you this. Their exhibits are not in evidence either.
Okay.
So if they're going to use them, they're going to have to put them into evidence. So the rules apply to both sides.
Well, I'm testifying as to what occurred.
Okay.
The
Okay.
first set of records that were produced to me, Your Honor, showed that Officer Merguido had taken 40 hours of funeral or bereavement leave within the time frame which I requested the records. The police department has a contract through their union that allows police officers to take up to 40 hours of bereavement leave if
I'm going to object, Your Honor.
dies.
I'm going to object, Your Honor, that he is testifying lack of predicate, and he's talking about speculation as well. He hasn't established that he has firsthand knowledge of anything that he's talking about. I would object to it and move to strike it.
Well, I'm not going to strike it, but certainly, Mr. McDonough, you're testifying as to hearsay,
Your Honor,
unless you have personal knowledge.
I have personal knowledge. A Homestead police officer shared with me a copy of the policy, and I can show you the copy of the policy if I can allow to share my screen.
Same objection.
You can share your screen. I don't have a problem you sharing your screen, except you can't share your screen and show me documents that are not in evidence. So in order for you to show me that document, you have to move it into evidence. And honestly, under the evidence code, I don't know how you're going to do that. You sure you don't want? Listen, Mr. McDonough, you can postpone this hearing, and you can get some advice of counsel if you wish. I'm not going to.
Well, let's just postpone this hearing because if not, we're just going to be wasting your time, Your Honor, and I don't want to do that.
Well, it's really your time. You pay for my time, so you're not wasting my time. But I see that it's going to be difficult for you to get stuff into evidence as we sit here at this moment. So I don't have a problem postponing this hearing. As a matter of fact, if Mr. Mandel doesn't have an objection at this point, we'll postpone this hearing, and you can I will entertain your motion for leave to amend.
Okay.
Mr. Mandel?
Your Honor, I just want to understand. So is Mr. McDonough, is he agreeing to postpone the hearing, or is he going to waive the hearing and seek leave to amend? Which is the path that he's going down? That's what I need to understand.
It's up to you, Mr. McDonough. I was going to give you an opportunity to postpone this hearing, start over again the next time around, And in the meantime, you can move for leave to amend. I'll grant the leave to amend, and then you can start from that point.
I'd like to postpone the hearing and move in the meantime for leave to amend.
Okay, if you okay, I just want to make sure we're all on the same page. Okay, because I know you're not represented by counsel. If we postpone the hearing, what I'll do is I'll I'll, I'll treat this hearing as if it never started.
Okay.
Technically, I'll declare mistrial at this point, and then I'll entertain your motion to for leave to amend, and then they can respond to it and so forth and so on. So it never happened.
Okay. Can we get a hearing set for the hear the motion for leave to amend?
No, I'll entertain it right now.
Okay.
I'll reverse my ruling. I'll reverse my ruling by denying it, and I will entertain it. And I'm sure Mr. Mandela is not going to go crazy about it. But I've already heard his argument on that issue. Therefore, I'm going to grant your motion for leave to amend your writ.
Thank you, Your Honor.
Your Honor, real quick, we don't object to the
I know you don't.
to the amend. I think it would be reversible error for not
Or,
to.
absolutely.
So, but Your Honor, I think that the amendment, though, I think moots out the need for a 11911 immediate hearing. I think.
Well, but see, Mr. McDonald's are represented by counsel, and although I got to treat him as a lawyer, no doubt about it. That's why I'm bringing to your attention your lack of predicate for your evidence. What Mr. Mandela is saying is that if I grant you leave to amend your petition, then you're not entitled to an immediate hearing on your 119.
Here's I think an easy way that we could settle this that would be equitable to all parties. If Mr. Mandel's clients would like to provide me the 6 set of responsive documents, which I've identified, they're aware of that I want. If they can't figure it out, they're more than welcome to contact me. I'll explain it to them. Then we could eliminate the claim for mandamus, and I'll file a different proposed Second Amendment complaint, and that'll help clarify and consume some narrow issues that the court has to deal with. If we can't do that, then I should still have a right to an immediate hearing because there's a record the city has not produced to me.
Okay.
I would preface my non-objection to leave to amend if Mr. McDonough expressly waives his 11911 hearing, which he can do, and then we would agree to leave to amend, and we can proceed on that case and then go forward. Mr. McDonough, if he's familiar with Chapter 86, which he professes to be, he'll understand what that means. So I would preface my non-objection for leave to amend. Again, I think he needs to waive the 11911. Or if he doesn't want to waive his 11911, he doesn't have to. And we can just say, let's go forward in 11911 hearing at a time that he's ready. But you can't have both. He can't amend and have the 119 hearing. I think he has to go forward with the 119 hearing first, and then he can amend it after that. Or he can amend now and just agree to waive it. The 119 hearing.
Your Honor, the entire reason for the immediate hearing is to determine if there's responsive documents and they're exempt. If they refuse to give me those 6 set of responsive documents, I have a right to a 119 hearing. And as opposing counsel has already stated, failing to allow me to amend the complaint is reversible error.
Mr. McDonald, Doctor, I like to call you by your title.
Yes, sir.
That's why you're there.
Thank you, Your Honor.
Okay, Doctor. I can't give you legal advice, so this is what I'm going to say to you. I will give you. I know the city is objecting to the motion for leave to amend. I will give you leave to amend. The consequences of you asking for it and me giving it to you, it's going to be determined at a later hearing when he files his motion for waiver of your 119 hearing. That's all I'm saying.
Well,
you follow
Honor,
you follow what I'm saying? I don't know what I'm going to do at that point because I don't have enough information at this point.
Your Honor, I think the proper procedure to follow is once the amended complaint gets entered, if there's a prima facie case made, then you would enter an alternative writ, and he would have time to file his answer or response to that.
All I'm saying is that he's got an objection to your amendment. I'm going to give you leave to amend anyway over his objection. The question is, what are the consequences to you seeking the amendment and me giving you leave to amend? That's all I'm bringing to your attention. We won't know that until later on.
I understand. I would request, and I would think would be the fairest way to all parties, is if you entered the alternative writ, forcing them to respond to the amended petition, and then after they responded, we can set a hearing at a time in the future that would not be immediate. I would agree to that. And I think
Right
that would
now,
be fair to all sides.
right now we're not there. I gotta follow the process because
Okay.
that's what I do for a living. So therefore, if you want to amend, I will overrule his objection. I will grant your motion for leave to amend. What consequences that are for you, that's I don't know.
Okay.
Okay, so you understand what I'm saying?
Yes, sir. Yes, sir, Your Honor.
Your
Okay,
Honor,
then yes.
I'm sorry. I didn't interrupt. I was just going to ask, by the rules, we're entitled 10 days. I would ask for 20 days to respond to the now, I guess, second amended plea. That's.
Oh, he's already attached it because I have a copy. It was attached to the motion, so it's being filed as of today.
Yes.
I've granted your motion.
Your Honor, I'm happy to give them 20 days to respond
Okay,
as
then
we would
you
get
got-
under
then-
the alternate writ.
Then you got 20 days.
Thank you.
Okay, now I guess I'll see you. So I guess this is over. Mr. Stearns, always good to see you. I like that beard. I tell you again.
Your Honor, before we close out, can I ask you for one more thing, if it pleases the court?
Even if it doesn't please me, I still entertain.
I love your sense of humor. Your Honor, there's a co-pending case. It's 19-034861. This is also in front of Your Honor, and Matthew Mandel is opposing counsel.
Oh.
It's the same parties, and it's basically identical issues, just different
You
requests.
you just ruined my day, Mr. McDonough. I didn't know that.
Is there anything I can do to get an immediate hearing in that other case?
You have
I
to
don't
you
need
have
discovery
you
or
have you have
anything.
to you have to file a motion.
I already filed a motion for immediate hearing.
Wait. You got a motion. You got to bring. Okay, you don't want to consolidate these two cases. Is that what? Maybe I'm
we could-
misunderstanding you.
I mean, I'm possible with them consolidating because it shows the pattern that I'm alleging the city in their violations of the law.
Okay, I'm not familiar with the other case because I haven't seen it yet. You file your motion. You can set it on my motion calendar. Yet I'm going to tell you right now that I'll be in trial for the next 3 weeks. Okay, doesn't mean my calendars are closed. Another judge, either Judge Bailey or Judge Walsh, will be hearing my cases. So if you don't see me, it's because you're going to see them.
Okay.
And so I'm just letting you know that in advance. So do what you need to do, Dr. McDonald, and we'll go from there. I can't do anything right now.
I understand. I'll confer with opposing counsel to see if you would like to consolidate them, or we'll go with them separately. Judge Bailey has heard one of these cases or a related case, so she's somewhat familiar with the issues.
I don't know who would cover it. It's most likely Judge Walsh, but I don't know.
Okay.
But somebody other than me will cover it if I'm in trouble.
All right. So, real quick, just to make sure that I'm understanding what's going on here. So right now we're postponing this. Mandel has 20 days to respond to the amended complaint that's deemed filed as of today, and then
Correct.
after he files that, me and him will confer and get with the court to set a hearing at some point in the future, or however we decide to proceed.
Correct?
The city has 20 days to respond. Yes, but me on behalf of the city. Yes.
Okay. Okay. Everybody's on the same page now?
Yes, sir. Your
Okay.
Honor.
Will somebody send me an order, please?
Your Honor, we'll prepare the order.
That'd be great. So it's always good to see you all. This is starting to be one of my favorite cases.
Likewise, Your Honor, and thank you again for the accommodation of postponing this hearing.
You got lucky, Mr. Mandel. But that's okay. All right.
That was
How
an
about-
interesting hearing that you went to on the special accommodation for those people.
Have a wonderful hearing. I mean, weekend.
Thank you again, Your Honor.
Thank you, Your Honor.
God bless.
Take care, Your Honor.